I'm your Washington Realtors legal hotline lawyer, and today we are once again reaching into the legal hotline mailbag to bring you this question and answer. Question: broker has been asked by broker's client to sign notices on the client's behalf. Client, for whatever reason, is unavailable to sign documents and wants to authorize the broker to sign on broker's behalf. Is broker allowed to do that? And I will tell you that I've also gotten this question in a broader spectrum to say, can broker sign a purchase and sale agreement, and can broker be empowered to sign the closing documents for a client who will be out of town at the time of closing? The answer to all of these questions has a technically correct answer that I will give you in the briefest form, because it's not the answer on which I want you to focus. The correct answer is the answer that's grounded in good practices. And in fact, it's my suggestion that every DB who hears this video should write an office policy prohibiting brokers in your office from undertaking any act of signing capacity or signing authority on behalf of a client. Because the risks of doing that, and I'll explain those risks in this video, but the risks of doing that are so great that as a matter of office policy, you should prohibit your brokers from doing that. And not only will that protect you as the DB of the firm and the firm itself, because your brokers won't be engaged in that practice, it also will give your brokers cover when they're asked by a client to do this for them. Because to the client, this seems very reasonable. Look, broker, you're the one drafting the notice anyhow. You think it's a good idea, or you wouldn't have drafted the notice, so just sign it on my behalf. That's a lot easier. I don't have to get somebody else involved, yada, yada, yada. And if broker says, I'm sorry, I would love to be able to do that service for you, but I simply cannot because we have an office policy that prohibits me from doing that, that gives the broker cover. Okay, so obviously you can tell from what I've already said that the technical answer is yes, this can happen. I'm not going to tell you how to make this happen. If you really want to do this, you're going to have to go talk to your own lawyer, to have your own lawyer help you set up legal authority for your broker to sign on behalf of a client. Instead, I'm going to tell you all the reasons why you should not, as a matter of office policy, engage in this practice. First, real estate brokers are licensed and provide real estate brokerage services to consumers. Anything that's not a real estate brokerage service, licensees have no obligation to perform for a client, but they also have no special training or expertise to perform for a client. So the act of signing on behalf of somebody else is not a real estate brokerage service. Second, it's not going to be covered by your errors and omissions insurance. Your errors and omissions insurance covers you for liability for errors and omissions committed in the act of performing real estate brokerage services. Signing on behalf of a consumer, on behalf of a client, is not a real estate brokerage service, so you're not covered by your E&O insurance. So let's say that broker signs that notice waiving the inspection contingency, and then buyer discovers some horrific event within the property that the buyer in hindsight can say, I never would have waived my inspection contingency. Why did you do that? Or maybe the broker makes a decision that the client immediately would say, well, that's not the decision I wanted you to make. That's not how I wanted you to sign that notice. There's all kinds of second guessing and different decision making that can happen with any question that comes up in a real estate transaction. So when broker signs on behalf of a client, they're not providing real estate brokerage services, so they have no obligation and no special training to provide that service, and they're not covered by errors and omissions insurance. Two huge negatives. So let's look at why it would be important for a broker to sign on behalf of a client. And really, there's nothing in that column. Because the only thing we could possibly put in that column is that the client has no other alternative. And frankly, in this world of modern technology, I don't believe that. I don't believe that will ever be true in any transaction. First, the client could be all the way around the globe and through electronic processes sign the notice or the purchase agreement or even the closing documents. And if for some reason the client themselves is so remote that they can't sign, they can have a trusted friend, family, their own attorney, or some other advisor sign their documents for them, even if that person is halfway around the globe. Electronic processes for gaining written authority, written signatures, is so rampant in today's world that there's no reason why a broker sitting in the location where the property is the only person who can sign documents. So the cons are enormous. There are really no pros. And designated brokers protect your own firm and your brokers by creating an office policy that simply prohibits your brokers from ever signing authority on behalf of a client or a consumer. If you have questions on this topic or any other, please send an email to me, legalhotline@warealtor.org. Thank you for being a Washington Realtors member.